Here are your Court News Ohio top stories in 5 minutes.
The Ohio Supreme Court on July 17th indefinitely suspended the law license of a former common pleas judge connected to the Cuyahoga County corruption scandal involving then-Auditor Frank Russo and then Cuyahoga County Commissioner Jimmy DeMora. Bridget McCafferty in 2011 was convicted of lying to FBI officials about phone conversations she had with Russo about cases that came before her in court. She served a 14-month prison term and is now completing 3 years of supervised release. In a 4-3 decision, the court found McCafferty violated multiple professional and judicial conduct rules, but did not believe it warranted her disbarment. The 3 justices who dissented in the decision said they would have disbarred McCafferty, saying she abused her power and swayed, quote, judicial outcomes for political associates. If McCafferty's case is discharged by the federal courts in September 2015, she can reapply for her law license in September 2017.
John Thatcher has known for 25 years that he wanted to become a judge when he first started practicing law. Now that dream turned into a reality as he donned a robe at the Mount Vernon Municipal Court on July 21st. Thatcher was most recently the Knox County prosecuting attorney. He also served as the assistant prosecuting attorney there and was in private practice before that for several years.
Really anxious to see what it looks like on the other side of the bench. I've had pretty varied experience, and I think that experience will help me in court.
Governor John Kasich appointed Thatcher on July 3rd to replace Judge Paul Spurgeon, who retired this year. Thatcher must run in November 2015 to retain his seat for the remainder of the unexpired term, which ends on December 31st, 2017. The Capital University Law School graduate said he is excited to begin this new chapter in his judicial career.
I've always wanted to be a judge and was tending in that direction because I've done so many different areas of law.
Thatcher said he wants to find ways for those who come before his court to avoid future felony convictions.
What I'd like to do is see if the municipal court can change some things about way people are handled, maybe through specialized dockets, to try to break some of that recidivism and find out what the core problems are.
Then he said those people's lives can get back on track and they will stay out of the court system.
The U.S. Supreme Court ruled last month that police need a warrant to search a suspect's cell phone, while the 9-0 vote in Riley versus California put the nation's law enforcement on notice. An Ohio Supreme Court ruling nearly 5 years ago already set that standard in the Buckeye State. The Ohio Supreme Court ruled on December 15, 2009 in State versus Smith that the Fourth Amendment prohibition against unreasonable search and seizures requires police to obtain a warrant before searching data stored in a cell phone. Justice Judith Ann Lanzinger wrote the majority opinion in the 4-3 Ohio decision.
In our case, it involved a cell phone that wasn't what you'd call a smartphone now. 4.5 years ago, we still recognized that cell phones were very different from laptop computers, from containers, and we said this is the type of thing that the Fourth Amendment was designed to protect, the interests that people have in the private things of their lives.
In the case from Greene County, Antoine Smith was arrested on drug-related charges after responding to a cell phone call that had been placed by a crack cocaine user acting as a police informant. During the arrest, police took Smith's cell phone and later searched the phone's contents without a warrant or his consent. Smith claimed his constitutional right against unreasonable search and seizure was violated, but his attempts to have the evidence suppressed were denied by both the trial and appeals courts. The Ohio Supreme Court ruling found a warrantless search is prohibited when there are no immediate safety concerns. The U.S. Supreme Court made the same decision in its recent ruling. Justice Lanzinger said even if there had been a different outcome in the national case, Ohio would still require search warrants.
And if the Supreme Court had ruled the other way and said, well, the police can do this without a warrant, our law still would have prevailed because the state can give more protections than the federal courts give.
At the time of the Ohio decision, neither the U.S. Supreme Court nor any other state Supreme Court had ruled on the Fourth Amendment implications of a cell phone search. In Riley versus California, the California State Court ruled in 2011 that a warrant was not needed for a defendant's phone taken by police officers during a traffic stop.
That's a look at Court News Ohio's top stories. Visit courtnewsohio.gov for the latest headlines on Ohio's courts. You can also follow us on Facebook and Twitter.